Okay, I'm going to call the Board of Abatement meeting to order at 5:31 p.m. on April 10th. Normally, I'm not the one who conducts the meetings, but this is the first meeting of this particular configuration of the board. So we have new select board members, and we have justices of the peace who have not yet had an abatement hearing. So the Board of Abatement is different than the BCA in terms of its makeup. The Board of Abatement includes the 7 select board members, the 15 justices of the peace, the clerk, the assessor, and the treasurer, whereas the BCA is the clerk, the JPs, and the select board members only. So before we begin, we have to have an organizational component to select a chair and vice chair. Historically, it's been the same as the BCA. It doesn't necessarily have to be that way, but we will entertain some kind of a motion to select a chair and or vice chair, however you'd like to begin. Do I hear any? Don?
I'd like to propose a motion that we continue the unofficial process of having the folks who serve on the first board serve on this board.
So for those of you who are unaware, Nancy Howe currently serves as chair of the BCA, and Sarah Blood serves as vice chair of the BCA, Board of Civil Authority. Do I have a second?
Second.
Who, second, Lynn? It went so fast. Is there any discussion or any other nominations? Hearing none, I'll call the vote. All those in favor?
Aye.
Any opposed? The motion carries, and I will turn the meeting over to the chair and vice chair.
Thank you very much, and thank you very much for coming out, because it does look like we have a quorum, and we always appreciate that. I would like to welcome Miranda and Eric as 2 new members of our board, as they were recently elected as select board members and are now officially also members of the BCA and the Board of Abatement. And the other, Ashley, could not be here tonight. She will be joining us at another time, but she will also be a new member as a new select board member. So we will be seeing her at another meeting. So I appreciate you folks coming out. And this is the first abatement hearing that I know we've had since we've had brand new BCA members and new select board members. So I think we're going to spend a little bit more time going through a couple of things about abatements generally. Abatements are quasi-judicial hearings, and there are very set procedures that we follow for those hearings. And you did have those, I believe, in the packet when you got your agenda. Lisa sent those out as well.
And I have a few extra copies here if anyone needs to have it in front of you right now.
And generally, and we do, as we start every abatement hearing, we do review those procedures, mainly to make sure for all the hearings that everybody at the hearing is on the same page, but also for the record. So either in the case of appeals or if anybody wants to review the recordings, they know what our procedures are. So we do that for every meeting. But today I'm going to do just a couple more things about the abatements. By law, and you saw this in your, I think, in the applications, there are very specific criteria that people can apply for an abatement. It is not for everything. It has to be pretty much, it's intended to be for pretty much extraordinary circumstances or temporary circumstances. Not so much, I'm sure, we could find that most of the people in town would be very happy to pay fewer taxes. But that's not a reason that you can ask for an abatement. So it is pretty, keeping in mind that it is not just something, just an ordinary that somebody doesn't want to pay something. There has to be circumstances surrounding that. And it becomes a balancing act between the taxpayer and the town. Whatever is abated for a person, whether it be the taxes or the water and sewer, the rest of the taxpayers have to make that up in the budget, or the budget has to be lowered, or water and sewer, the rest of the ratepayers pick up that extra. In cases where it's actual taxes, if we abate, and all of this doesn't necessarily apply tonight, because we won't see some of these tonight, but if taxes are abated, we still have to pay the educational taxes to the state. That goes there. We strive really to be fair and respectful to every applicant that comes, but we also need to be fair to the town. So that's where sometimes that's hard to look at that. The people, you have a right to ask for an abatement, but no right to get an abatement. That's totally up to the board. And it is the responsibility of the applicant to provide all the documentation and evidence to the board, to convince the board regarding their case. The board members do not do any research on your own. It is totally what you hear in a hearing that we're to look at. The other part you may have seen on there is no what is called ex parte communication. That's before that you talk to anybody regarding the issue, the parties involved, or any of their representatives, or anything about the case. There's no talking about that before the hearing. And I will ask before every hearing if anybody's had any ex parte communications. There's also, I'll ask about a conflict of interest, if anybody has any conflict of interest on any particular hearing, if you recuse yourself. So again, the board has total discretion on what you would like to do, depending on what evidence and documentation the applicant provides to you. You can grant the request, you can deny the request, or you can grant it in part. It's totally up to the board to make that decision. And we do make those decisions after the hearing. We go into a deliberative session, which is not public, and where you will discuss the evidence and make your decision on what you think should happen. In the deliberations, the only evidence that you can consider is what you have heard in the hearing. And I often say, sometimes if you know something about a particular case that you think is pertinent, raise it during the hearing. Ask the applicant about whatever it is, as long as it's relevant to the situation. But there's no new testimony in the deliberations themselves. So that's just an overview a little bit about some of the responsibilities that we look at. There's whole other stuff that as we go along you will find out. But that's just a quick, some of the most important parts of what we have to think about as we go through this. So before every hearing, as I said, we go through the procedures in the following sequence. And what I will open the hearing stating the name of the applicant, the property location, and the parcel ID. And we ask all applicants to take an oath, which is at their at the seat where they'll be sitting. They read the oath and affirm that. You ask for any ex parte communications or any conflict of interest on this particular request. I'll ask the applicant if they've received a copy of the rules of procedure and whether there's any questions that they have on that. We will ask them to affirm or explain the particular category that they've chosen their request under. And that's when I said earlier there's the very specific categories that you can request an abatement. And then the applicant can present both verbal and documentary evidence to support their abatement request. After they have done that, we'll open it up for questions from the board. And when the board has all their questions answered, we'll close the hearing and enter into the deliberative session. And they will receive a written answer within 30 days. What we have done, instead of doing a deliberative session after each hearing, we've done all of the hearings in sequence and then proceeded to deliberate on all of them. That works out time-wise more efficiently so we can keep the hearings on schedule. And sometimes deliberations take very little time for a case, but they also may take a long time. So that works out better. So are there any questions? Lisa?
I have a question. Just one thing that I don't think I heard you mention. Because we're a quasi-judicial board, although all of our meetings are open to the public, they cannot participate. It's not like going to a select board meeting. They can't ask questions. They can't interject. They can sit and observe only. I think we've only maybe once had anybody do that, but they are technically open to the public, but it's pretty restrictive about that.
And we do all of the hearings and the meetings are recorded, and under the new open meeting laws, they are posted for 30 days after the meeting, so they're available to anybody. So, any other questions, comments, silence?
I'll just remind people who've never been through this before, there are times where your heart's going to be torn, and because some of these are hardship cases, and when the person is in front of us, one, they've come into a room of this many people. When they come to get the applications from my office, I forewarn them how many people will be in the room, but I also remind them we all live here, and they will be treated with respect, and we understand that they just need to come and tell us what your circumstances are, how you got here, why you're asking, and then the board will deliberate. But it can be pretty daunting for them to come, and there are times when it gets pretty emotional for us and for them. I'm not sure we're going to experience that tonight, but as Nancy said, there's a balance between listening to our neighbors and also understanding we have a responsibility to the town. It doesn't mean you have to, there's no hard and fast rule, and there's no precedent setting. Each one of these is really de novo.
Right. I think that's
every case, even if you've had a similar one in the past. One, the board may have changed, and even if the board hasn't changed, maybe the membership who's attending has changed. So you don't have to go back, hey, well, remember we did this one. It may not be, you start brand new and you just rely on the information that's before you to make your determination.
It's got little special pieces to it, so they're all different. Scott?
Are there any cases that we spoke of in the last meeting that when we were together, we talked about like the group things? There was the new piece of the law. Are any of these tonight in a similar like locale or anything that they do? No.
They're not.
No. Scott's talking about there's a new part of the law that is just passed that we can clump a group of requests together into what's called a class, and it's usually based on something that has happened to a group of people, the same thing, a similar thing. Either it's one, I think it came out of a lot of the flooding out there,
Right.
is where it happened. A lot of people lived in the same situation. Or there could be a mistake made in the taxing or in the Worcester's office or wherever it happens to
Could
be.
have a wildfire in a neighborhood,
Or a
just
fire in
something
the
like that.
neighborhood, or made a mistake that a whole neighborhood was subject to. So it has to be pretty specific
Right.
to a group of people. You can hear that as a group, but you do have to treat everybody in that group equally. Once somebody decides They can opt out of being in the class if they choose to, but once they're in the class and you make a decision, everybody gets the same result. And so far, I think you mentioned we had one flooding that could have been
Right.
in that class.
I can recall that. Yeah.
Yeah. But so far, there's been not any others.
So another thing I'll just say, and I haven't done this yet myself, but as soon as I do, I will share it with you so I at least can be doing it with some level of experience. Quasi-judicial boards, along with the select board and other legislative bodies, are now required to take an ethics training as part of some of the legislation about ethics that came down through last legislative session. It's about a 45-minute to an hour training. I started taking it the other day, and our office got busy, and it timed me out, and you have to start all over. So I haven't had a chance to do it. I will do it within the next week to 10 days, and then I will send you all the email that has the link on where you can click in. With some general instructions. For us in Hartford, I believe John Haverstock has been designated kind of as the representative. The select board maybe could find the right terminology for me for information to go to regarding, but when we take this course, we have to notify someone. So instead of it coming to me, I'll give you John Haverstock's email, because he then has to report that we have taken this training. I will also provide to you a link through the Vermont League of Cities and Towns for the open meeting law. There were some changes last year. Some of you may have already taken. It's just a webinar. You could take it at your convenience. But you do have to establish an account with VLCT in order to do that. Just username, password kind of thing. You would. But again, I'll send you some of that information. But those are just things to be aware of, since this is a new start to our terms.
I did have that under other.
Oh, sorry. I always jump. Nancy and I, we get in each other's way sometimes.
But since we started under other and we still are waiting a little bit, I've got really good other news for you. At town meeting, Mike Morris made a motion that the BCA members have an increase in pay to $100 for every 4-hour session or part thereof. So your pay has doubled.
Starting July 1.
From $50 to $100. And it passed, and starting July 1st, you'll see an increase in your pay, and I hope it doesn't put you in a new tax bracket.
So we're to deliberate more slowly.
Unless you want to stay here more than 4 hours. So do you want to, we know the first person's not coming, do you want to start with one wait?
What's the pleasure of the board, I guess I would ask.
We'll start.
Sorry.
Yeah, so the first applicant notified me he was unable to come. And just as an aside, he had requested a translator, and I'd like to thank Scott Farnsworth for helping me procure a translator. I did end up having to cancel her because he told me due to his work schedule he wasn't able to come. But it was a really good exercise for me to have to do that. And I'd reached out to resources that are approved contractors through the state. I reached out to Dartmouth College and reached out to Scott. And through all of those efforts, we were able to find some avenues to find a translator. And we don't get the benefit of experiencing that tonight, but it was a good exerise.
Yeah,
for sure, but he did say he couldn't be here.
I think it was really kind of nice. We just put that, I think at Scott's suggestion, a year or so ago on our application, asking if anybody needed any special, had any special requests. First time it's been used, so I think that's great. And thank you, Lisa and Scott, for the work you did in getting
That was, frankly, that was really great because we have ELL staff in the district. So I just reached out to them, and they had someone that they use that's fabulous in school that work with their kids. So that was really just nice between the school and the town to kind of
Right,
join
yeah,
that way a little bit. Great.
yeah, that was great. So I will open the hearing.
I have a question on that.
Yes, sure.
Are there any services where folks can get assistance on the application? And if so, are translation services offered for the application assistance as well?
I think people can get any assistance they want on the application, other than...
If somebody asked us for that assistance, I would do just what I did this time.
Okay.
It wouldn't be instantaneous, but I would do everything I could to find that assistance for them. If it wasn't something we could, if it was language, I wouldn't be able to help them with that. But if they didn't write or they're illiterate, something like that, and they just needed assistance completing it and telling me what to do, we could certainly help do that. And I don't see that as a conflict in any way. It's literally just transcribing for them. But if it had to do with language or something like that, I would do just what we did this time, which is find a translator if they didn't have access to one themselves. I think that was kind of the goal, to make this as open
Yes,
and available
as possible.
to people as it could be. So
Lisa, can I just mention, I worked at Dartmouth Hitchcock, and we had access to translators from many, many, many languages, so that might be
Okay.
another resource for you.
great, thank you.
Yeah.
And I did notice in the new regulations, for a lot of them, the state has to provide the forms and the information in 5 different languages, and so I think the state has access to that as well.
And I did go through the state, so as well.
Anything else before?
Do applicants usually show up?
For the most
50-50.
part, yes, for the most part they do. They are not required to, and sometimes they choose not to. Other times there's a conflict and they don't. But even if they are not here, if they've put in an application, we are required to act on it, to address it and act on it. So this applicant, I'll open the hearing for 131 Depot Street LLC. It's the applicant, represented by, I'm not sure how you pronounce his name, Chang In Ni. Property location is 131 Depot Street, parcel ID number 75250, span number 285-90-15676. As you can see here,
This is public now, correct?
yes.
Yes.
Should we have the doors open? Doesn't really matter, I don't think anybody's here, but
No, I mean, they still could come in even if the door was closed. They'll usually just peek in. We usually just have the door closed. People want it open. I'm happy to have it open. Your preference?
okay.
So as I said, he has not had let Lisa know that he was not able to be here tonight. We are going to act on this request. And so does anybody have any ex parte communication regarding this hearing or any conflict of interest in regard to this? He has checked the category of a clear and obvious error, and he has asked for an abatement for water and sewer charges from March of 2024. In his application, he said that he had asked for the water to be shut off. Somebody came from the water department, shut it off for him. He watched them do it. However, he still continued to be billed for water and sewer for that.
May I join you?
Have a seat here, and then we'll put you in the hot seat later.
Thanks. Excuse me.
And in his application, he included these water and sewer statements. And I'm going to, and you also have in your packet, there was an email thread of communications between Lisa and DPW and the finance department. And I think also added to that, you've got copies of his actual water and sewer bill.
Yeah, so I handed
That is
those
what
to you
he
today.
has provided, or what you have received in your packet. He is not here to answer questions, but Lisa has had further communications with people regarding this, so she
So
can
typically,
move
for
forward.
every application, I add to their packet the property, assessor's property card, so I add that. I typically reach out to the finance department to get the most current billing history that we can, to try and get a feel for where we're at that point, because sometimes it'll be a couple months before we have a hearing after someone has applied. So this came back in March. And then I reach out to to Department of Public Works if it relates to water and sewer, just so they can tell us what the circumstances were from their point of view, so you have that information. Those staff members do not typically come to our meetings, so we try and get that information so you have as full a picture as you can. Are you looking for me to provide something specific?
Right, you had said you have additional information and a little bit clearer review of actually the amount of money that might be appropriate.
So in the billing history, he provided some billing history. It's 2 sides. It's immediately after his application in your packet. So it starts with the billing date of 1/2/2024, and it's 2-sided. So I got updated information. I found this a little bit confusing, and then we got the finance department's several pages of the same kind of billing history, starting from back in 2023, which does not apply in this particular case, but they weren't quite sure where to begin. So I asked them to explain this to me a little bit. And just to give you a sense for codes, IS means the interest on sewer, IW means interest on water, and then the W just means water, the S means sewer, and then it kind of tallies down. And one of the things I found a little bit confusing, because I don't normally read these, is you have a bill date and a due date, but that doesn't really give you a strong sense for the period of time that we're talking about. And these bills are done quarterly or in quarters. And so the finance department went through with me where this all begins. So if you look at his sheet, which is the first side of his sheet after his application, the bill date was 5/31/24 and the due date was 6/30/24. This covers the period of March through May, March 1 to May 31. So if you looked at the email exchange between Department of Public Works and the Finance Department that I included via email and in your packet, he had the water turned off on or about March 13th of 2024. So you're really working forward March 2024 to current as you're trying to tally payments. And then he basically continued to pay even though he was in, what he's arguing is he should not have been charged because the water was turned off. And I think there was an internal snafu between DPW and the finance department. As I spoke with Brian Gazda, the director of DPW, and he explained they have a policy that it's up to the homeowner or property owner to notify finance that they've had the water turned off. So we had...
Did you ask him, do they notify the homeowner that is their responsibility to do that?
I didn't specifically ask him that, but he commented that internally they were going to look at it to see if maybe a form would go from DPW to finance instead of relying on the property owner. Now, I don't control either of those departments, but it seemed like this is more of an internal communication issue based on what Brian was saying. He's not here to speak to it directly. It was a phone conversation I had with Brian Gazda, but it sounds like there is not a clear way for finance to have been aware, and then finance is not authorized to refund these monies without it coming before us. So it's a little clunky, but that was the impression that I got. So as finance also told me in terms of how the interest is calculated, the first 30 to 89 days you are assessed a 1% interest, and after 90 days it's 1.5% interest, so it may change over time. Thank you, Brandon. And so he gave that information to me, and then basically what I did, don't know if this is right or wrong, somebody who's much better with the numbers than I can say, I basically went from that bill date of 5/31 forward and tallied up the 127.93, which was the amount billed for that period. So what happened is once the water was shut off, he was billed only for the base rate for water and sewer each. That's why it's so low. So the base rate for water is $45.01 and the base rate for sewer is $82.92. That comes to $127.93. And I basically went through, and sorry to jump around, but I'm going now to the ones that finance provided, which is a little further along in your packet because you get the full picture. So if you find the utility billing account history that's dated 4/2/2025, starting with page 1, and skip ahead to page 3 of that one. It's a 4-page, 6-page document. Have I lost everybody? So behind the property card, the assessor's property card, the finance version of the utility billing history is immediately behind that. And on page 3 of that, you can get back to the bill date of 5/31/24 and the due date of 6/30. And again, that covers the March to May 2024. So I went through and I tallied the 127.93. And then the next period, it was 127.93. The next period, it was 127.93. And I tallied those together. And if I did my math right, it came out to be around 513, 515. He is asking for 511.79. I didn't find exactly that number in any of my calculations, but it's in the neighborhood of that amount. So I was, this is something we'll deliberate about during deliberative session, but I wanted to explain how he got maybe to that number or close to where he's asking for that to be abated, because he shouldn't have been billed from his perspective since the water was turned off. He should not have been billed during any of that period. I did not try to prorate March 1st to March 13th, 2024, which would have been a period of time where the water was still on of that quarter.
Are there any questions, Don?
Maybe I missed something in the reading, but how is he told that he's supposed to notify?
In theory, I think DPW would have explained their policy, and they may have. He is a person who would have had a translator here, so whether it got lost or whether it didn't get told, that's a piece of information I don't have. So I don't think anyone's trying to blame anybody, but what is highlighted here is that perhaps the system could be better.
Could be a system.
Yeah, there could be a system in place of notification between departments, and also to the applicant,
They were saying
to the property.
communication at its best is sometimes awful.
Yeah, and sometimes we all think it's obvious, and it just isn't. So that's why we're here.
Are there any other questions? Adam?
As far as base rates go, if a property's water is shut off, they don't have any obligation to pay any base rate?
No,
That was my understanding, even in hearing back from,
it's totally shut
Even
off.
though they continue to have access to the water,
No,
should
they
they?
they don't.
But should they decide to turn it back on, they don't have to?
They can't. The town turned it off
I know,
at
but
the
They
street.
could ask for it to be turned back on, I'm saying.
Yes,
They could.
Right.
Yep.
So there's no obligation to support the infrastructure in that time period, though, that they still maintain access?
That's not I didn't get the impression from the communication that you can see in these email exchanges, I didn't get the impression that would be a
And
requirement.
actually, I got the impression from reading it, there were some issues with the meter or whatever section there was there, that there was some problems with that too, that needed to be fixed before it could even be turned back on.
That's a very deep
Miranda?
question.
I know that costs are, if there's an abatement granted, costs are then the town's responsibility, whether through taxpayers or ratepayers. In this situation, would that be the case, that ratepayers would need to cover the costs of the refund?
It was only in the sense that I guess in this case, no water was used at all. So that's just the base rate, so there
Okay.
was no water used. Lynn?
On this new one that's not on my computer, but the one we got tonight, you can see that the usage is every time 0. There's nothing under
Right.
usage. So there was, except the last 2, there's a 1. Except that, if you look at the meter reading, it's the same from the beginning to the end. It's 8147, it shouldn't be 8148 or 8149. Actually, one unit of water is being used. But it's clear to me that there's no water being used.
Anybody else? Eric?
Kind of in the math that you described, you said you added 127.93 times 3.
I don't know how many times, I literally did it on my calculator, 1 through each.
I guess are you also adding the 83 cents and 45 cents for the, and if not, maybe I missed why.
You mean at the end? The 80, that was a penalty, I think, or what he hasn't paid maybe. So it says principal balance, the 83 and 45 that you're looking at. Are you on page 3 near the bottom?
I'm on page 3, for example, not near the bottom, but
At
right
the
after.
bottom on page 3. Or at least on mine, you look at
Yeah,
something.
the
I'm looking at, yeah, I guess there's, under principal balance, okay.
yeah, so it's possible those haven't been paid, whereas he's been paying other things. If you look at the principal balance before that, so that the principal balance that's due right now, Eric, as you pointed out, is the 83 cents, the 45 cents, and the 127.93, showing a principal balance of 130.49. But so he may just not have, those are interest on sewer and water on the previous payment of 127.93 is the way I look at that.
Okay.
So he didn't pay that one, but previously he'd been paying that bill.
All right, thank you.
Anybody else? If not, I will close this hearing, and we will go into deliberative session later and deliberate and make a decision on this particular request. The next, I guess, there's an indication on the next one in order for Elizabeth Taylor that she would not be here. I don't know if we want to wait and see, or
What,
it's, she is scheduled
for 6:20?
for 6:20.
Do you want to jump ahead?
A few minutes, or we can switch the agenda a little bit and
We have one applicant here, the one who is supposed to be here at 7:20, but was gracious enough to come early just in case we
I'm
had
an overachiever.
in case we had a gap. So
Given the fact that she has indicated that she would not be here, my suggestion is that we alter the agenda and move the request from the town of Hartford up. How do other people feel? Is that something you'd like to do?
let's do it. You can take either of those hot seats if you like.
I will open the hearing for the town of Hartford on the Grace property, formerly the Hannon property. Here, speaking for the town of Hartford is John Haverstock, the town manager. The property is located on 41 Winter Street, parcel ID number 45-255-41. Span number 285-090-11535. Welcome, John, to the Board of Abatement.
Appreciate it. It's my first rodeo, so be gentle.
And for those of you that may not have met him, it's John Haverstock, the town manager. And in front of you, John, it's a paper with an oath on it. Will you please read that oath in the form affirm?
Sure. Under the pains and penalties of perjury, I solemnly swear that the evidence I will give in the cause under consideration shall be the whole truth and nothing but the truth.
Thank you. Has anybody had any ex parte communication regarding this case, or does anybody feel they have a conflict of interest? If not, did you receive a copy, John, of the board's procedures?
Yes, I
did. Do you have
did.
any questions
I don't.
regarding those procedures? And the statutory requirement that you identified in this particular situation was?
There's two, actually.
Okay.
First, that taxes or charges are in the account of a person who has died. And I don't know about solvency, so that'd be the top category. The second to last category would that be that the taxes or charges are upon a mobile home that has moved has moved from the taxed location.
Okay, thank you. So, if you would please tell the board what the situation is and what you are requesting?
Sure. As the delinquent tax collector, that's another hat that I wear sometimes. I work with Lana Livingstone in my office with regard to delinquent tax accounts. And there are several where we have not received any kind of answers and many times received unopened mail returned by the postmaster, presumably undeliverable. This is one of several of those situations. So I began to make inquiries about Mr. Hammond, and it appears that he was the owner of a mobile home which was located at the Chambers Mobile Home Park at 41 Winter Street in White River. He appears to have died on March 20th. A Google search provided me with the photograph that I put into your package. It's his headstone, indicating that he died on March 20th, 2022. Mr. Hammond became delinquent on his property taxes back in 2016, and there is a property tax statement that I provided dated February 13th of this year. And for those reasons, I'm recommending that the town abate the taxes accrued, including penalties and interest, for the period of his ownership, or at least through the fiscal year 2023, totaling $8,343.39. Why did I pick that set of parameters, 2016 through 2023? Well, that's because at some point the mobile home disappeared, by all accounts, and a new occupant of that lot has bought her own mobile home and placed it on that location. I presume since the town bills according to address, that Tanisha Boyce has been billed on this same account, even though she had nothing to do with Mr. Hammond, simply succeeded his location at the mobile home park. So it seems to me that the fair thing to do, and to also clean up some loose ends in terms of our record keeping, would be to abate the apparently uncollectible taxes that had accrued under Mr. Hammond's ownership.
Excuse me,
Welcome.
sorry.
Are there any questions? John? Questions? Eric?
Yeah. Is there any way to track mobile homes, like to understand what you mean by issues here? Whether it was sold perhaps, or?
There is some provision in the materials I've received from various sources such as the Vermont League of Cities and Towns that say this is a frequent occurrence for mobile homes. They're easily moved and sometimes disappear in the middle of the night. I have no idea where this mobile home may have ended up. The suggestion that I've received in those materials was that as the delinquent tax collector, I might want to seek an abatement of the taxes. For example, in the VLCT handbook for collectors of delinquent taxes, revised 2022, there's a discussion of taxation of mobile homes, and there's a section devoted to mobile homes that have disappeared. And in one portion, it says, in many cases, the mobile home is never located, and the collector must attempt to have the outstanding taxes abated so that the delinquencies might eventually be removed from their records. And for me, it's a matter of really just removing an uncollectible account receivable from our books, so it's a more accurate statement of what's out there and collectible.
Mark, had the town attempted to deal with this after 2016 when it was delinquent?
I don't know. I do know that sometimes these mobile homes are taxed at such low rates that it's not worth staff time to pursue. Of course, over time, the amount has accrued to $8,000, $9,000. I also note that during the COVID era, there was a moratorium on tax sales, and the town was pretty standoffish with regard to tax sales for the early 2020s. So I'm just here as the relatively new town manager, relatively new tax collector, seeing this issue on my desk and wanting to address it.
Brett?
I don't have a conflict of interest, but I do know the mobile home. It was not in a livable condition, and after he passed, I'm sure it was dismantled or just went away. It wasn't, somebody came in and hauled it away. It was not in a livable condition.
That's good to know.
Lynn?
I would think the only way to try to find the former home would be to contact the owners of the park to see if they know if they removed it, as Brett said.
Well, it was dismantled. It was dismantled.
I remember actually early on when I began to look at this, I was down in the clerk's office, and sometimes Sherry is a good historian of these kinds of matters. And I think that the impression I had after talking with her was that no one knew where the mobile home was.
It's pretty easy to dismantle a mobile home down to they just dismantle the whole thing, and then all you've got is two steel beams, and those beams are probably sitting in the park, but the home is gone, so.
Lynn?
When I used to walk around the park when I was campaigning, many of those homes were in not livable condition.
And sometimes when they come up for tax sale, the town is loath to bid on them for fear of having to take ownership.
That makes sense.
it sounds like some of this, I mean, is a moot point. I mean, suppose the board said no. So where are we?
It's really, from my point of view, just more of an accounting exercise.
Exactly, we're clearing the books is what basically what we're doing. But I would like to take a few minutes, if you don't mind. We were basically a relatively new board. We have been inundated, no pun intended, with water and sewer requests, and we have not had terribly many tax issues come forward. I'm anticipating that we would see a lot more of that for two reasons. I think it's now required anytime, whether it's water or the tax department sends out a delinquent tax bill, there has to be a notice on the bottom about abatements. And I think we might see some of that tonight. And with the reappraisal coming up, I'm anticipating we're probably going to see more tax issues coming forward. So sort of using this as a basis, this case, if you could help a little bit explain some of the process so that we know what happens before somebody actually comes here. In this particular case, I noticed that he didn't live at that site. And the bills, what happens, do we just keep sending bills?
Yes.
And what happens
they
when...
keep coming back, and Lana has a big stack of them that she refers me to.
And then what, if they are returned to you, what does the town ever do? Do you do anything else, or you just keep stacking them up?
Well, I suppose, again, if the stakes were higher, the town might make more aggressive efforts to be in touch and to try to collect those taxes.
And this may be more of a finance department question, but that is part of my question. At what point do you make further effort to contact the actual taxpayer versus just keep sending bills over and over again?
Right.
And whose responsibility? I know they can set up payment plans, but does the town ever offer that, or is it totally on the...
I do know that the post office cannot forward mail unless there's been a request by the owner or the person being sent. In this case, the person was dead, but you could, in an ideal situation, have a family member request the post office, but they won't allow you to forward mail if it comes to your address unless the person who's getting that mail has requested the post office.
And I suppose some of your question could be more easily answered if we had phone numbers for these people or email addresses for these people. And I certainly didn't have that information here.
And if we're in this hearing, so I'm sort of using this as a basis,
Sure.
and I'm also talking a little bit generally.
If you'd like,
What part does the town take in trying to recoup these, other than just constantly sending?
Well, certainly there is the pressure of rising interest and penalties. And generally speaking, people don't want to see those penalties and interest accrue. If the taxpayer is delinquent for 2 or more years and the balance is more than $1,000, we will put those properties up for tax sale. After, of course, writing a firm letter stating that we're concerned and that we're going to be handing the matter off to legal counsel. When we have a sufficient number of accounts that are in that mode, we do reach out to that counsel. It's now Stephen Ancuda. That's our town attorney with regard to these matters. And he then sends his firm letter, which tells the delinquent account that the town has tried to reach you without success. Now I, the attorney, am reaching out to you. Please be aware that we're about to start incurring costs that will be charged to you for my time, my research at the town hall, for newspaper postings. So all of those are increasing in costs to the homeowner, which again hopefully put pressure on them to come forward and to talk with us about a payment plan. We're definitely willing and eager to have payment plans, but in order to be eligible, you must have demonstrated a good follow-through on any previous plans you had in place. It's easy to make a payment plan, but so many people do end up violating the terms of those payment plans, which leaves us at square one. So we have to have some history of good cooperative relations, or if it's a new person, then of course we assume the best that will happen. Then at some point, When the tax sale attorney has performed his or her due diligence and research, he then or she then posts notice in the town of the impending tax sale, and then ultimately conducts the tax sale. Tax sale consists of a lawyer like Steve Ancluda sitting in a room like this and announcing all the properties that are up for tax sale, giving the homeowner that one final opportunity to bring their taxes current. If they don't, then they're often sold to third-party investors seeking to make money on the interest that grows on tax sales after the sale. There is a one-year redemption period. Even after the tax sale, the homeowner can still redeem their property by paying all of the penalties and interest and taxes, plus the attorney's costs and fees.
Do you anticipate any more tax sales coming up?
We do. We've got about 40 properties that are in this category. The lawyer has just sent off, I'm told, his firm letter telling them that a tax sale is forthcoming. And often, in my experience at least, that does generate some real movement among the homeowners.
In the case of someone that has passed away, goes to the estate, and is the estate responsible? Like in this case, there was nothing to do?
No, only the owner of record is responsible for debts. Those are not the responsibility for family or friends, I'm afraid.
Okay. And does, I guess, there's a new owner in this particular case?
Yeah, not of the home, which of course has disappeared.
Gone, but she has.
But she's in that location now.
Right, she has purchased her own home.
That's right. And I can imagine if she were to receive the bills that we've been collecting, she might be quite startled to see the balance.
Well,
So that's another reason why I'd like to clean out the prior history.
This is one of the reasons I asked that, because I noticed on the bill, it did go to her, and it was big.
Yeah, I don't quite understand how internally we handle the generation of bills and why they would be on the same account, other than the fact that they're in the same location.
Yeah, and that was one of my questions. And does she know that you're asking for an abatement? And
She does not, but when she came and first introduced herself to, I think, maybe Lisa or Sherry and me, the discussion was, wow, I see a big balance, but clearly not all of that's going to be mine. Please find out how much I owe you and I'll pay you. So since that time, Rick Vincent has been out to assess the value of the new mobile home, and those numbers are now plugged into our billing system, and we will send her the bill, hopefully without all those prior years on them, so that she knows exactly what she's due, and I presume she'll make payment.
So she, at this point, has not got it. Well, we don't know. We don't know anything about.
Yeah, I don't think she would have gotten these bills, because Lana presents them to me each month because she knows this is pending out there. And I don't think there's any benefit to providing sticker shock to poor Miss Boyce.
No. Well, I just asked, I don't know if there's any other questions, because I do anticipate we may have to do some more tax stuff. What actions the town takes when we hear from.
And trust me, I take no pleasure at this role, right?
Mm-hmm.
But it's not fair to the other people who do sweat and make the payments due or honor their agreements to hold everybody to the same standard.
Scott?
Can I just ask, you mentioned, Nancy, the new assessment coming out. What are the dates, John, for, so we know what for? Okay.
New dates for,
Well, I'm curious, if someone's gonna get a notice of, your property's been reassessed at blank and blank.
the letter should be going out in early May.
And that, excuse me, and then help me, the taxes are due when the next round of taxes.
The bills go out in July, and from what I understand, it'll be based on the new assessment.
Right.
After the grievance process, there'll be a window for grieving.
Thank you, right. So back to Nancy's point, we likely, until someone gets a bill.
They need to get a bill, go through I guess they get a chance to go talk to the company first for an informal, make sure everything is correct. Then they go through the official, with timelines and everything, grievance process with the assessor. And then if they're unhappy, then they can come here after that.
Well, they come to the Board of Civil Authority. They would not come to the Board
Well,
of
no, I'm sorry.
Abatement. Just
yes,
want to
the
be
Board
clear.
of Civil Authority. We're the Board of Abatement tonight. We're all the same people,
Yeah.
but we have different titles.
Yeah, I would just say that the presentation that was done at the select board meeting 2 or 3 months ago, that was very helpful. It's-
But you'll note that that was a more optimistic timetable.
Yes.
Consultant has been a little slow to follow through, but
Yeah.
we're pounding on it every day.
Yeah. Okay, that's helpful, thank you.
Is it, Eric?
John, you mentioned there were 2 reasons for the abatement request on this one, and one of them was the person who's died insolvent. I didn't see any evidence that the town collected on insolvency. The risk of asking the indelicate question, is there any evidence?
I don't know, actually. That's a good point. It's a good point. I don't know. The town is a creditor in that respect. So usually if there's an estate, all the creditors are notified as part of the probate process. I certainly see nothing in the file having to do with any statement on his behalf, on behalf of his estate, notifying us that there's a will or any assets.
Okay, thank you.
Is that information that the state would have? That information, is that information the state has in terms of whether?
I don't believe so. It might, if anywhere, be in the probate court that has jurisdiction.
In this case, there were surviving children, adult children, but there was no estate except for the unusable mobile home, and they just abandoned it.
Okay, I think, unless, John, you have something else, or anybody has another burning question, I will close the hearing and we will do the deliberations and let you know.
Pleasure to meet everybody.
Thank you, John.
Even if I can't recognize you under your different hats.
I have Mr. Romani here.
Okay, let's,
Do you want to go to Mr. Romani since Ms. Stoller wasn't planning to attend?
we can,
If you'd like to have a seat in either of those chairs. Sure. There's an oath there.
Is someone going to swear me in, or
well, I'm going to,
do I swear myself
it's
in?
real formal. I'd like to welcome you to the Board of Abatement. Mr. Romani, is that how we
Yes,
pronounce your
ma'am.
name?
Yes, ma'am.
And I'm going to open the hearing for, is it Taha? How do you-
Just like it's spelled, Tahoe with a T. Tahoe.
Romani and Jenny Friedman for the address of 8 3rd Avenue, parcel ID number 45-200, span number 285-090-16215. And in front of you, since there is an oath, if you could read it to yourself and just affirm that oath to us.
I affirm.
And does anybody on the board has had any ex parte communications or has any conflict of interest in this? If not,
Being a neighbor doesn't count.
unless you've had coffee. Did you receive a copy of their procedures?
I did.
And do you have any questions on the procedures?
No, ma'am.
You'll be following. And the statutory abatement category that you checked off was, tell us what that one was.
So it was taxes in which there's a clear or obvious error or mistake of the listers, 24 VSA 1535A4.
Thank you. And would you go ahead and tell the board what your situation is and what your request is?
Sure.
You did receive your packet of information.
So it's a pretty simple situation. We bought the house in September. We chose not to put our taxes in escrow when we bought the house because I knew that I would set up the auto pay and do it myself. I went ahead and made an account with the billing system, and I set up auto pay. I set up the text reminder or whatever it's called. I received email notifications that the auto pay was set up on January, I believe it's the 26th. If you look at the top right of each of the exhibits that are attached to the exhibits list, they're not numbered, but you can see this is what you all are looking at is screen caps of my own Gmail account. They were taken by me, and they are true and accurate to my actual Gmail account. So you can see that those messages and the dates that they were received, those emails and the dates they were received, these are emails I received from the town of Hartford's billing system. I didn't know if I needed to, so I redacted the account and invoice numbers for some of these documents. And it's pretty simple. I set up the auto pay with the expectation that my taxes would be withdrawn in a timely manner per the billing system. What I didn't know was sometime after I had set up the auto pay, and this was a quick turnaround because I set the auto pay up on the 26th of January, and then I received an email on the 29th of January that my taxes had been paid. And so sometime after that, I guess the previous owners of the house were billed instead of me, and then they contacted the town and provided proof that monies had been withdrawn from their bank account, and so the town reimbursed them for that. But no notice was given to me. I didn't get an email, hey, we sent you an email that your taxes were paid, you were expecting your taxes to be paid, but by the way, this whole thing happened and now your taxes are not paid, so you have to go fix it. I didn't receive any notice of that. I had the clear expectation that my taxes not only were going to be paid, but were paid. I have a receipt in my email inbox. So I was kind of surprised when I received the delinquent tax notice after the fact in February. So at that point, I called the town. I spoke with, I think her name is Carrie Thibodeau. She was very nice. I explained the situation to her. She looked at the billing system, and she corroborated from her side, from the town side, that what I was saying was correct. I did sign up for auto payment. I should have had a reasonable expectation that my taxes would have been paid on time. And then she also is the one who let me know that there was that issue with the previous owners of the house, that they had been billed and then that they had refunded, that the town had refunded them. And so I think it's a pretty reasonable request on my end that I was expecting my taxes to be paid. I did what I felt like I was supposed to be doing, which was I put my information into the billing system that the town provides, and I had a reasonable expectation that the billing system that the tax was using would bill the right person on the right time. And then on top of that, I didn't receive any notice when the wrong person was billed, so I didn't have a chance to fix it myself before the deadline. And so I understand $104.40 is not the largest amount, but we have a young family. My wife and I got married like a year and a half and just bought the house, so $104 is a lot of money for us. And I figured it was worth the time to come here after work and just explain the situation. I don't think it's a very complicated thing. So the evidence is in the paperwork. My understanding is Ms. Thibodeau emailed you guys. She provided me a copy of that email corroborating my story. And so I don't think it's a very complicated issue here.
Thank you. Does anybody have any questions? Rick?
Can you help me understand this a little better? So it says here that on January 29th, you made the payment and you received payment confirmation.
So no. So I set up auto payment on the 26th.
Okay.
And then on the 29th, I received an email saying that was a payment confirmation.
Okay. But you hadn't made a payment?
I
Where I'm
said,
confused is you said that the prior owner made a payment and they were reimbursed. So it sounds to me, if I'm following this correctly, that you both made a payment, they were reimbursed, but then you were delinquent somehow?
so I set it up for auto payment, so my expectation was that the billing system would pay it for me at the right time.
Okay.
And then they made a payment 3 days later on the 29th. And so a reasonable person who sets up auto payment on the 26th and then gets an email on the 29th, hey, your bills got paid, would make a correlation between those things.
Yeah.
But and I don't have any verification of this because I'm not looking behind the scenes like you guys are. But my assumption here is I set up auto payment and then they themselves paid the bills, or auto pay billed them. Maybe there was some kind of priority system or something for their auto pay, and so then they got a confirmation too. I'm really not sure what happened.
I'm following
with
now.
that.
Okay.
But then at some point they called the town. So I don't have anything in my bank account from before when I actually paid.
Okay, I understand now, yeah.
Sure.
Thank you.
Mark?
In fact, though, you did owe the $104.
No, that's a penalty for something that, this is penalty, this is not his taxes. So this was assessed because of the error that the system appeared to create.
Correct. I'm not asking for a reduction of the taxes that I actually owe. I'm just asking to be reimbursed for the penalty that was assessed
Right.
because
You
I was
paid the
delinquent.
taxes and there's penalties and interest given in the timing of how everything took place.
It's a big penalty,
Yes.
isn't it?
Anybody else? If not, we are going to, I will close the hearing and we will enter into deliberative sessions shortly and we'll let you know. Within 30, you'll get a written confirmation within 30 days.
Okay. Thank you very much. There's no reason I need to stick around, is there?
No.
Okay. Thank you very much.
Thanks for your time, Taha.
Thank you.
Should we go back? Do you want to check to make sure that
Yeah, I'll see if the
ACES,
ACES folks are here. If not, no, and I don't know if they were planning to come. I don't know if they were planning to come, but there's no one out there that is related to this.
okay. So should we go back to,
I would go back to Stoller, I think. Yep.
you have in your packet a request from Elizabeth Staler, and I don't believe she is here, so I will open the hearing for, I lost my thing here. Elizabeth Staler, the property location is 1893 Willard Road, parcel ID number 32-46-1, span number 285-090-12821. And she said in her information that she didn't think she would be here today. But she has asked for abatement of penalty and interest for late fees for paying late taxes. Does anybody have had ex parte communications about this case or have a conflict of interest in this particular case? And she has checked off the category of unable to pay. And in your information, for the record, she has indicated that she's a single parent. She had a baby in November, and she's in a home that she had intended to have help in sharing expenses for that home, which is not happening, and had what she claims is a very high property tax height and find it financially difficult to pay. And she said she thought she would get a postcard reminder to pay.
Nancy, could I, since the copier, the way it copied, the very last line in her handwritten notes on the front was cut off of your copy, so can I just read to everyone
yes.
what it says?
Yeah.
In the line above it that you probably can see, it says, it would make a, and then down where it was cut off, a big difference to waive these fees and revisit the enormity of the overall tax increase on some households. So the way it cut off, I apologize, but it's just how the copier pulled it in. So I just wanted to share that.
And that same, could you, somebody please read the second sentence? There's a word that shared. I'm a single parent who owns a home that was intended
To be shared, but is not.
Thank you.
Right.
It's not a shade.
Thank you.
That's part of her claim for her inability to pay.
Got it.
And to quote her, she also said in there, as you saw, that she considered this a significant burden for a small estate. She has provided a tax receipt and her tax billing statement, but no further information.
The other thing I would add to that is I added up what she was asking for, and the actual number is $216.69. She's asked for $216.99. I know that's not significant, but I think it's just a calculation error, or she wrote down the wrong number. But I just in open session just wanted to say that.
Can you repeat that number that you?
It was $216.69 is what the actual number is versus $216.99. So not significant, but just thought I'd bring it out.
Question.
Are there, Mark?
She says in her note that she expected to receive a reminder or notice that's due. And the question is that the standard practice or is it not the practice?
No, several years ago, they did do postcard reminders, but it's been, I don't know if somebody remembers how long, it's been a while since they've done that.
Yeah,
But they have also, it's on the listserv, it's been in the newspaper multiple times. It's also on the board out front that goes with, there's information, it's on the town webpage. There's constant reminders that the taxes are due in February, as well as being noted on your original tax bill when the second payment is due. All right.
Is there a reason that that practice was stopped that anyone here knows of?
Probably cost. You have two stubs at the bottom, and they found, with technology, you'd have to ask John or people that have been here longer than us. But also there's so many ways to publish that information.
I was going to say that list of ways that the word gets out. I'm a taxpayer, but I wouldn't have accessed any of those ways of that the information is published, except driving by this sign. So I was just mentioning that there's a category of people who don't access those things.
Yeah, there is also it is on your tax bill.
Oh yeah.
There are two payments that are due, and the date for the second payment is on the tax bill.
Another question. I can imagine people do forget. 3 different times a year. How common a problem is it? I mean, how often are people missing the payment and being?
There's a significant number that miss the payment. I can't tell you if it's because they forget.
Okay.
So every year, this year it was really significant, but every year it's in excess of $2 million. This year it was more than that by the deadline. But I don't know that you're ever going to know that it's because someone forgot.
But most people just swallow the penalty.
Right. Sometimes.
Yeah.
In this case, this is one of the hardship not to take a stand, because I'm not taking a stand either way, but this is one of the hardship types of cases that you're going to see. She's pleading her case to you in writing as to why these the penalties, she's not asking not to pay her taxes, but she is asking that the interest and penalties be forgiven just because of her circumstances. So it'll be up to this board to decide what they feel is the right approach.
Yeah, in deliberations. But it also, I think you're going to see more now that it's required when people get their delinquent tax notice, that there is now a notice that they can appeal to the Board of Abatement. So I think you're probably going to see more of that.
And if I can add, wearing my select board member hat, I actually have had at least one other person ask me about this specifically because they were going to be late on their property taxes and have been used to this reminder system and forgot, and they were like, now I'm going to be late, and they were like, can you do something? As soon as I was elected, the next day, they were like, can you do something about that? And I was like, I'll look into it.
But it's been
I mean, I've lived
decades, I would say.
and I've never gotten a.
Okay, or it also is possible, I may be conflating that a little bit, they have properties outside of this area as well,
So different towns bill differently. So ours are just 2 stubs on the bottom.
Are there any other comments or questions in the open hearing on this particular case? If not, I will close the hearing and we will discuss it in deliberations. The next one,
Do you want to wait till 7 since they weren't due to be here till 7? What is your pleasure? Is there someone else? Well, is it the same person that's been sitting in the chair the whole time? Because he's been here since 4 o'clock this afternoon. No, he is not the person we're looking. Miranda knows because he comes to select board meetings regularly. He is just an interested community member who attends meetings, etc.
That's the way the contract is. You know what, I mean,
no, I think you should say that because exactly that.
I think it's probably, given that we have a little gap, it's probably healthy to talk a little bit about conflict of interest and generally there could be legitimate conflicts of interest where I think the threshold is, do you feel like you can make a fair and impartial decision, even because every single one of us in this room someday will see someone we know, our kids went to school with them, we live next door or something. So if those were considered conflicts of interest, at least this is my opinion, we would never be able to hold an abatement hearing because everybody in the room would be recusing themselves. So I think that litmus test is, can you be fair and impartial in your deliberations on this particular case? And if there's a situation where you don't feel like you can, let's say there's a horrible hardship situation and you know way more than maybe is shared in the application or somehow you've been involved, then there will be times for legitimate conflicts of interest, but just knowing someone or having a glancing knowledge. But we usually do, what will happen is we will go around, well, I have been talking to, I've known this person, and then that's the question, and then the rest of the board.
So can we do that part of it? Because
when I will ask if anybody has a conflict of interest.
And then you can just say it?
Said, somebody speaks up and tells what the issue is,
and you can kind of get a feel for the room and
if
your own heart.
If the room thinks that yes, you should recuse, then that's usually the better judgment. But it is up to the individual.
It definitely is.
It's the individual's choice. And I guess what I sometimes think about in terms of like neighbors, we all know people, or we have neighbors. If it's a neighbor where you go have coffee every single morning and they watch your cat when you're on vacation, and they plow your driveway, that may be a case. That's pretty close, you might. But if it's the neighbor who you wave to or talk to in the summertime, when you're outside, that's a different story. So again, it's up to you on how intense or how close the relationship is to make that decision.
Since we still have another since I don't know the status of these folks, I would like to wait until 7 at least. I'm just curious, now that we've been through 4 hearings, 2 applicants here, does anyone have any just sort of procedural questions, that now that you've been in it, rather than just the overview, or observations, not necessarily that would relate to deliberation about any of these, but just really generic things that now that you've had a couple hearings before you might have come up where you had no point of reference before?
Eric?
I have a question. So for example, if an applicant has a question with their water bill, and we don't necessarily need to know all the details about the property, for example, are you statutorily required, or do you just have by policy or procedure to include the property information and so on?
I just do it as a matter of course. I mean, I'm the one who started adding those. Sometimes in the past, when I first started, applicants would include it. I started adding them because there were a couple instances when I first started that we either had a fire, so they lost use of portion of their building, but maybe they had a garage that was not impacted, and there was still value in the land. So we were trying to calculate what abatement you would give. And in the beginning, when I first started, it seemed like fewer applicants would spell out what they were asking for. Now we're a little more pointed about it. In the last 7 years, we have revised this a couple times. We've had some really good input from these board members about what it should look like, and then the legislation changed on something. So we're a little more specific about getting them to answer those kinds of questions. But the reason for water and sewer, it wouldn't apply, but I just do it to be consistent at this point. But that's why we include them, because it was really hard. For instance, if the assessor didn't happen to be available to help us with those kinds of calculations, we were trying to calculate it based on value for each of those items when they have a loss of a property for a period of time. Is that?
Yeah, I mean, it certainly makes sense when there is a physical property issue that is part of the...
If you don't want them included with water and sewer, I don't have to. I just do it because I'm in that mode.
Just looking around the table, it's X number of copies, and so if you have discretion and are allowed to, I didn't know if it was like required by statute, you have to provide certain...
It is not.
I mean, it's not, I don't necessarily object to it, but it is extra paper, it's extra printing, and in some cases it would seem perhaps not necessary.
I think in some cases it's not necessary, but I mean, I think we have had a couple of water cases where it involved land and where the water line went across the land and boundary lines.
Yeah, those are cool things.
Nope, that's not him either. That's Mr. Hashimoto.
I have a question. Sure. Just when, so I understand that if there is an abatement is granted, similar to my previous question, that the taxpayers as a whole will then be responsible for covering the cost of those taxes. If it is a penalty and late fee.
Sorry, that's what I'm trying to shut off.
If it's penalties and late fees that are being granted, are those costs needing to be recouped? Or are the penalties and late fees kind of just erased?
I think they're just pretty much erased.
Okay, I just wanted to make sure that I...
and we talk about the cost to the town. I mean, some of that is a philosophical thing as well. I mean, if somebody's asking for $500 abatement, I mean, in the overall $1 million budget, that's not a huge thing. Yeah. But unless you get 25 people asking for the same thing, but again, it comes back to the fairness issue too. Other people in town will pay all their things.
Just to add to that, I mean, it's not as though we literally bill people extra because of these abatements. It's just becomes part of the overall picture of the town budget that we have a little less income on the previous year. But we
I just
have-
didn't know if the penalties and late fees were being counted as like a loss.
Well, penalties and late fees are part of the income that we budget for the town, the revenue. We make estimates of what we think the revenue is gonna be, or Gail does, the finance director, based on historically how taxes go.
Yeah.
So I think she tends to make fairly conservative estimates of revenue, knowing that sometimes there's abatements that happen. So it's not like a one-to-one, it's not like, oh, we gotta minus this out, because the budget is a projection.
Yeah.
Good question.
That is a good question. And good explanation.
Yes,
But
thank you.
I'll check outside one more time, but it is
Okay, otherwise I think
7:01, so let me just check. No, I was looking for somebody else who I'm waiting for, but thank you. I don't see anyone else out there. So I think we go ahead and start. If they walk in and you haven't closed the hearing, I guess we're good to go.
Okay, so I will open the hearing for John and Arnold Aces of 32 Demers Avenue, parcel ID number 43-52, span number 285-090-15475. And the applicant is not here. Does anybody have any ex parte communication regarding this case or any conflict of interest?
So it's not really what I consider conflict of interest. They were neighbors of my dad, and John, who knew him as Mike, took care of my dad at the end of his life. But I have no problem being fair on this hearing.
Okay, does anybody else have any concern about that?
Nope.
If not. So he has requested abatement of $118.98, I believe. It again is late fees for his taxes. He has, he said his, as you see in your packet, he paid off the property late last year and was told by the mortgage lender he would receive a tax bill in the mail. The bill was sent to another house, and he was out of the country since November and just came back and saw the bill. Went to the town as soon and paid the tax bill, but also received the penalty and interest. Linda?
Just as a point of order, I believe that the writer of this is Elaine, the wife. The wife is, because they've included the Korea boarding pass, Korea air boarding pass. So I don't believe that you're referring to it as John is asking for this. This, I believe, is written by Elaine.
Yeah, I said we. Yeah.
Okay.
No, when I opened the hearing, I used both of them.
Okay, I thought you were saying he.
Oh, maybe I did.
Yeah. I did, but it's they.
He, she has included their airline boarding pass and a property billing statement. Beyond that, and property seems to be at 32 Demers Avenue, however, his address is 41 Demers Avenue. And he has indicated that on the request that he was requesting the abatement because of service charges caused by circumstances that were difficult to foresee or outside of a person's control. Mark?
In connection with the previous question, if the wife, assume it's his wife, was the one who was out of the country, he presumably was in the country and could have gotten the mail. There's nothing to indicate that.
He's saying it went to a different house, so if they own two properties and they rent one out and it went to that house instead of their own mailing address. So what I don't know is where the bill went, because as Nancy pointed out, their mailing address, according to the property card, is 41 Demers Avenue, but the property address is 32 Demers Avenue. So they may own two properties, and it may have gone to 32 Demers Avenue, and let's say they rent that property and nobody gave them the mail. I'm just playing devil's advocate. I'm not
Right.
suggesting.
It was interesting, he says, we paid off the property tax, but it says I was out of the country.
Right.
The wife was out of, so one person was out of the country.
And they do live at 41, they live directly across the street.
But
Okay.
they were out of the country in November, and bills would have come out last July.
Well, they would have been, need to be paid in August, and there's a lot we don't know. They're not here to answer any questions.
Here, which
They
bill
pay-
was it?
Pardon?
I'm wondering which bill was it they didn't pay?
Well, that would be a question, did the mortgage company pay the August bill, and then they would got a new bill? There's just no...
I think paying
without
off your
somebody here to
mortgage
answer
doesn't
those
trigger a new
questions.
bill, I don't think. So,
I'm also confused if we're talking about taxes or on the next page, it's sewer, water, utility, or service charge. It's like what's checked off as the,
Except he circled it beyond the water, it goes or service charges caused by, and he's looking at, or he or she is looking at the charges, the interest and penalties as service charges.
interest penalties on a tax.
Right.
Property tax bill, okay. Okay.
Are there any other questions, other than we don't know where the bill went, and who? It seems to be discrepancy on who was out of the country, when.
It appears to me that on the bill that on page, it's like the fourth page, it does have that they've written town clerk abatement, and I think that if you add those two figures together, you get the figure on the front, right? But it certainly looks like it went to the 41 Demers Ave, which is where they live.
Right, but that's,
Was this provided, Lisa, was this provided by you or by them?
this was provided by
Is it your handwriting,
them.
or?
Nope, that's not my writing. So the first billing statement, which is on the back of the boarding pass, was provided by the applicant. The other billing statement after the assessor's property card is the one I got from the finance department. But again, it may tell you where the bill was sent, but we still don't know which house it was delivered to.
Right.
Their testimony on their written testimony is it was delivered to the wrong house. So, again, not playing devil's advocate, just a clarification. That's a piece of information we don't have. If they were here, we could ask them.
Something, and the assessment from the finance office is $243,000, and the assessment on the tax card is $121,000. So which property is it?
it looks like these 243, is that the one you're referring to? 243,200?
Well, one
Is
has
there
that,
assessed?
but then the tax card, I assume is the other house down.
I might have pulled the wrong tax
Yeah,
card,
that's
too.
That's 32 Demers. The property card's for 32 Demers, not 41.
But he's saying the location of the property on the application is 32 Demers Avenue. Their mailing address is 41 Demers, so they own two properties.
Right.
And then it gives you the parcel span ID of 43-52, which is the one that I pulled.
Right, and it does say the location underneath that is 32, even though
Correct.
Yeah, it is
they
32.
went to, or the address they should have gone to was 41 Demers Avenue, but the location was 32.
Correct.
So a couple of things, thank you. I wouldn't look at that 121,600 too hard. This card was printed out on March 20th of 2025, so just a couple of weeks ago. So that assessment has changed, and the reval company's still working on the assessments, so I wouldn't put any weight on the 121,600. So the,
I'm not
No, wait,
necessarily
no, I'll
waiting on
take that
just wanna
back.
Make sure that it's the right.
Yeah, they're not letting.
Yeah, I'll take that back, because the 2024 assessed value is 121,600 on the property card, but on the bill it says 243,200.
If are they contiguous properties, so they're all on one bill? I'm trying to look at the original application so I can tell you if I can read it better.
That could be,
One is 41 though, and one is 32.
Demers Avenue goes between the two properties.
So they are on the assessed value on the backside of their application, they're the ones who filled in 243,200 instead of the 121. So they may, I don't know if they added the two.
It's on the billing statement
bill.
as 243.
But in essence, is that of our concern right now? I mean, they're requesting.
They're just asking for the
Maybe
fees.
out there, I just saw somebody, I just had them aside, I thought I just saw somebody walk by. To the left.
Just forgot my keys.
And I do have one other.
Yeah, Rick.
It was asked a few minutes ago about if they had made the August payment, or which bill they were talking about. And if you look at the property billing statement, let's see, get my bearings straight here. You look at the property billing statement, it looks like they made the first payment. I did see that somewhere. Down towards the bottom, this date of August 7th, 2024, says payment, electronic, 1982.87. So I think what they missed was the February payment, which would align with their trip. They were in Korea, I think.
Yeah,
Mine was,
November.
but my question really was, who paid that August payment? Did they pay it, or did the mortgage company pay it out of escrow?
Yeah.
And so they were expecting another bill.
Right, so the mail didn't make any mistake, there just wasn't a bill in November, because we don't get a November tax bill.
Unless, I don't understand, unless in the process of paying off your mortgage with the bank, there's all kinds of liens and stuff you go through. And part of that is dealing with property taxes.
Yeah.
So maybe at that point, you do get a second bill when property gets paid off.
I don't know.
That's like just, that's prorated for the amount of time that you've owned that property.
Right.
And even if your mortgage company's taking care of your taxes, you get a copy of the bill.
Yes.
So
Right,
they would have
correct.
gotten a bill last July.
Yes.
Right.
So it sounds like they were expecting something from the mortgage lender that they
Or they get
didn't
something in
see
the mail,
whether
what they
that was a
got.
mistake or not. But it wasn't really on the town.
Right.
You just stated, I've never received a bill on my house, ever.
Really?
I do. I received one in my taxes are escrowed. You're supposed to. You're supposed to.
How do you know what to pay?
Mascoma.
No, but you're supposed to receive it, as does your bank, so.
Check to make sure that your address is up to date on your tax card.
Yep.
I don't know.
You're gonna be filing for a
They're all paid, that's the next part.
I'm making all
Well, I
this.
didn't know that.
Because, well, I live in Queechee, so I don't, so if they have it on the house, it would never get to me. It have to be. Yeah,
Do you have a
that's a good thing. I mean, I've
That's
never done, it's
interesting.
all done electronically, so. But
Okay, I think,
Yeah.
sure, see.
Well, I was thinking, one of their points is that the bill is misplaced somehow, right? What if the post office doesn't deliver a bill? Stuff is not getting delivered these days. It seems like it's still on the taxpayer, right?
Yes. Anybody that relies on the mail for anything at this point.
I mean, it's a bummer that it's not.
Yeah, but it's not the town's fault when the mail So, anyhow, we're moving into
Yeah.
more time about it. Are there any more questions that we want to have in an open hearing before we go into deliberations? If not, I will close this hearing and we can deliberate to.
Do you want a motion to go into deliberative session, or?
Well, first of all, does anybody think they want a break? A quick one? No?
I'm just gonna stand up.
I'm going to turn off the tape recorder. That's why I'm asking if there's going to be a motion or not a motion to go
Well,
into deliberative session. Or
Let's make a motion. I'm not sure we really need one, but somebody make a motion to go into deliberative session.
I'll make a motion.
So we'll have a time.
I'll second it.
Okay. All right, turning off the tape recorder.
Should we vote, Lisa?
Oh yeah, shall we
All those
vote?
in favor? Aye. Anybody opposed? Okay, we're in a deliberative session. We need a motion on,
Who did the motion to come out of deliberative session? Mark.
And Eric seconded.
Okay.
all those in favor? Aye. Anybody want to stay? No? Okay. So we'll need a motion on the request regarding 131 Depot Street LLC from me. That's how you pronounce it. Somebody that will make a motion.
I can. I motion to approve the abatement for 131 Depot Street LLC with the amended amount of $516.84.
Is there a second to that?
Second.
It's been seconded. Is there any further discussion on that motion? Not all in favor? Aye. Anybody opposed? Motion carries. I don't know how if you want to go the way we did it or
Just the way we did it.
down the agenda.
Let's do it in the order in which we actually had the hearings.
Okay, then we went to the town of Hartford. Is there a motion on the town of Hartford? This is the boy's property.
Move that we abate this thing. Sorry, I lost my words there. But this amount, $8,343.39 for the town of Hartford.
Second.
It's been moved and seconded. Is there any further discussion? If not, all those in favor? Aye. Anybody opposed? Motion's carried. The next one we did with Mr. Raymond regarding the confusion on who paid the property taxes and where between the old owner and the new owner, and we have the confirmation with respect to town. There was a communication mix-up. The motion, he is requesting $104.40.
I make a motion that we approve the abatement of $104.40 to Mr. Remini at 8 3rd Avenue.
Seconded.
It's been moved and seconded. Did you get a second there, Lisa?
Was it Sue, Sarah? I could hear it from that end of the table. Who made the second? Sarah?
Why not?
It's been moved and seconded. Is there any further discussion on this motion? If not, all those in favor? Aye. Anybody opposed? And the motion carries. The next one was Elizabeth Staler. And she has requested interest and penalty abatement, $216.69. Is there a motion?
So we'll abate the amount of $216.69.
Is there a second?
Seconded.
Okay. Is there any further discussion? All those in favor? Aye. Anybody opposed? Motion carries. The last one is John and Arnway Aces of 32 Demers Avenue. Let me just discuss this one. Is there a motion?
I move to deny the abatement request of $118.88.
Is there a second?
Jeez, there are so many people to choose from.
Is there any further discussion on this motion? Not all those in favor of denying the abatement request? Anybody opposed? That motion carries and the abatement is denied. And is there any, did we do them all?
Yep.
Is there any further business that anybody needs to bring before the board? If not,
Oh, just a real quick question. So we've just approved $9,181.52. So now tell me what the process is. Does it go back to whom?
it'll go up to the finance office, and depending upon if they've already paid, they can either get a refund or a credit towards next bills.
We should decide, we should direct the finance department as to what to do. So now that, so let's.
We don't even know if they.
Well, yes, you do. You have all their statements in front of you.
Yeah.
So is the will of this board, because I can determine that, if they have paid, do you want them to get a refund? If they have not paid, then it's forgiven, so they get a credit, basically. Is that how you want to approach it? I mean, historically, that's how we've done it, but usually it's spelled out, and I didn't really catch that as we were going along.
Yeah, what's the alternative to that?
Those are your two alternatives. You either get a credit or you get a refund.
And can they be given that choice? Can the Treasury say to them, do you want this or that?
No, we
Or
state.
would you prefer that we say
We
that?
should state it in the decision letter because, as you can see, the departments don't like to make these decisions because it's you as this board. It's this board's responsibility to direct.
Right.
And even the decision letter, which you don't have a copy of, says this applies to interest, penalties, taxes, water, sewer, this portion, and it breaks it out. And then I have to check off a box, credit or refund, or both sometimes it's both, actually, depending on the circumstances. So if that's how you'd like me to treat it, I can make that determination based on the history, unless you guys want to go back through each one and tell me specifically.
So here's the other question. If they've already paid it, I do believe they should get the refund. But if they've not paid it, then why wouldn't they just wipe it off the book?
Well, you credit them, that's how it wipes out, because it's due, so if we credit it back, it zeroes it out.
It zeroes it out.
That makes sense.
Okay.
It isn't really a credit like towards the next bill.
Yeah.
You don't get that?
No.
So they forgive it, basically.
But they
We've
could,
got
if
it.
they didn't want a refund, they could request
But they have-
credit if we left it up to them, but we're just not going to leave it up to them.
I think this brings closure. This brings closure, there's nothing.
Right.
Correct.
Yeah.
I have a question. Does a refund affect the town's finances in any way? Is it?
Just like Ida described, that's less income that the town had coming in. So if they've paid it and they get a refund, that money now is going back out of the coffers potentially. And so in this case, with the exception of the town request, they're all modest amounts, generally speaking. So in the town situation, they're not getting a refund because they never collected it. Right. We're just zeroing out. The town is asking let's clean up our books because we're never going to collect this $8,343 and change. But as Ida pointed out earlier, if we're giving a refund, yes, that's less money than the town has collected now.
Right.
If they've already paid, because a refund would come only if they'd already paid it.
Mm-hmm.
But if the only one that has any significance to everybody else's tax bill is the one that the town happens to know about because they're bringing it forward, I have a feeling John is good enough that he already figured this out and put it in the budget, I would guess.
And there, as I'd also pointed out, Gail Ostrout sort of anticipates based on history delinquent taxes or unpaid taxes over a period of time. So that is built into your budgetary process. I know you haven't had to go through it yet, but it is sort of built into, there's going to be a certain percentage of people who don't pay their taxes, and
And actually, you can see.
And they
that
won't all
amount.
come before you.
It's in the town report. You can see the total amount of delinquent taxes that are outstanding.
but it won't be for this tax cycle. That would have been last year.
Anything else? If not, we'll take a motion to adjourn.
I move to adjourn.
Good job, Sue.
It's undebatable.
Who seconded, Sarah?
Good job.
Thank you,
Thank you very
guys.
much, everybody.
Thank you. So there's a box